Morning, everyone. Richard Seller here with another video blog. I want to start doing a series that discusses sort of the behind-the-scenes workings of what goes into a case based on employment law, the types of things we do during litigation, what we look for as far as evaluating whether we can proceed on a case or not, and things of that nature. So I'm going to start today's short video with the topic of, Rich, what makes you take one case and not another? And I think it's a good topic and something that I can sort of explain in terms of why do we take some cases and not others. So let me start with the basic premise that I always tell clients, which is the following. There's a big difference in employment law between unfair and illegal. Let me say that again. There's a big difference between unfair and illegal. Let me explain to you what that means. So Florida's what's called an at-will state, which means employees can be fired for any reason, a good reason, a bad reason, even a fake reason, so long as it's not an illegal reason. So what's an illegal reason? An illegal reason is being fired based, for example, on your pregnancy or on a disability or because you require medical leave or because you're black or Hispanic or white or beyond the age of 40. So these are topics or areas where the law says employers cannot fire employees if the motivating reason for the termination decision is these, what I call immutable traits, things that were either born white or Jewish or Catholic or obviously pregnancy doesn't fall within that category in the sense that, it's something that comes about over time, but it's still protected nonetheless. So if you're fired because you had a disagreement in the workplace with your boss, if you're fired because your boss thought that your register was short and it really wasn't, that falls in the category of unfair. And by unfair, it means, in essence, yeah, you may disagree with the decision for termination, but that doesn't mean that that's illegal and that you can pursue a claim. And the courts are really clear on this. The courts use the expression, it's not our job to sit as what we call they use the quote, super personnel department to evaluate every decision in the workplace. Instead, what the courts say is it's our job to send a case to a jury if there's a dispute of facts as to whether the true or motivating reason for the termination was something illegal, which also, for example, could include you observe that your employer is doing something illegal, you object to it, which makes you a whistleblower, and then you get fired, okay? Also, as you guys know, we represent employees in claims for wages where they're not being paid overtime properly, or there's a breach of an employment agreement that says an employee should be getting paid X wages and they don't get paid those wages. So I'm not going to go through every single type of case we take. If you're interested in learning about our services, certainly go to our website, www.floridaovertimelawyer.com, and we talk a lot about the specifics of each category of case that we take. So, Rich, why do you take some cases and not others? Well, the first dividing line in determining whether I take a case or not is whether there's any potential avenue for illegal versus unfair, okay? So I can tell you candidly, we generally ferret out very early on in evaluating cases during our free evaluation process whether this is an unfair situation. And we always give the advice, if it's unfair, look, we're sorry, there's nothing we can really do, the law doesn't prevent it. But if we find something that we think is illegal, obviously we're going to dig a lot deeper into that and see if there's something we can assist with. So oftentimes we'll get an allegation of, let's say, for example, age discrimination. I'm just going to use it as a topic, but for any of these examples, substitute the word age with religion or race or disability if it applies to your situation, and you can see sort of the analysis that we do. So let's assume somebody comes to us and says they believe they were fired for being older. So what we're going to do is we're going to look at the circumstances of their employment and see, for example, whether if they were fired for reason X, were younger employees not fired for the same reason? Were there comments made in the workplace, such as we've got to get rid of older employees? Again, substitute whatever words you want for, we're tired of Jewish employees having to observe the Sabbath, things like that. Obviously, in this day and age, employers are getting smarter and smarter, so you're not generally going to have the typical get rid of James, he's too old, we hate old employees, and we need to bring in employees not so old. We do get some of those cases, but we dig deeper and evaluate and analyze whether there's what we call circumstantial proof. The one I gave you, for example, is whether younger employees are treated differently, whether the employer has a pattern or a practice of getting rid of older employees and replacing them with younger employees, things of that nature. And you, as the potential client, are certainly going to be in a better position to feed us with that information than we are, because we didn't work in that workplace, we didn't exist in that workplace, so we're relying on you. Oftentimes, clients will have emails or hiring forms or other documents, even little things that say we need fresh blood or young blood, things like that, and that gives us more corroboration or support for our claims. So look, are there times where we don't get it 100% right? Absolutely. There are times where we'll either turn a case down because we don't believe that there's enough evidence, and 2 years down the road, I'll get an email as a, haha, you didn't take my case and look how great we did. It's not a perfect science, folks. A lot of it is based on gut and intuition, and we make these decisions based on what's available to us at the time. So what I always tell clients if they disagree with my assessment, if I don't take their case, is look, there's tons of other lawyers out there. They may disagree with me. If I had a crystal ball where I could, prognosticate that this is absolutely a case and they're going to pay hundreds of thousands of dollars or $1 million, of course I'd be taking your case. And what I always tell clients is I have every incentive in the world to take your case if I think there is a case, because that's how we get paid. If I don't take your case, I'm not earning any revenue either. I'm not getting anything back. So if you have a case, we absolutely have every incentive in the world to work alongside you and fight for you and with you. So if we do decide to accept your case, what we generally do from there is we get you signed up, where we have you sign a retainer. It's a contingency. Again, as we discussed in a prior video, you don't pay anything. The only way we get paid is if we recover for you. Once we get your retainer back, we spend, some time, it could be weeks, it even could be a month, 2 months, or 3 months, investigating the company, investigating the nature of your claims, seeing if they've been sued before for similar allegations. And from there, what we normally do is we then send a demand letter out on your behalf. What the demand letter is it's a letter that says, hey, look, we've been retained by Janie Smith. We believe she's been discriminated against. Here is our understanding of the facts and why it's illegal. And we're going to give you an opportunity before we go right into litigation, into a lawsuit, to see if you want to discuss resolution. And if we're wrong, tell us why we're wrong. This is how we do it as a firm. We're not running blindly into a court. That's dangerous for the client. It's dangerous for us if we file frivolous cases. So we give the employer an opportunity to show us their hand and their side. And most of the time, I would say 85% of the time, the parties are able to come to some sort of agreement and a resolution that results in a nice severance or payment to the client. If that doesn't happen and the employer says your client's lying, your client's got a whole different case than what they're telling you, we go back and analyze again. And at that point, if we believe the client more so than we believe the employer or the employer's lawyer, at that point, we make a collective decision with the client to file suit. That's going to be a whole different set of videos, but that's what I'm going to describe this, what we've done here today is the pre-suit aspect of an employment case at our firm. I'm going to create a number of other videos that talk about each step of the way in the litigation process so that clients understand exactly what it is we're doing. So again, guys, I appreciate those of you who are out there watching this. If you find it helpful, let us know. We're putting this content out for you guys in hopes that this helps you guys make better decisions with regard to not only retaining an employer, but figuring out what it is you need to do next in your employment cases. So Richard Seller, Tuesday morning here. Have a great rest of the week. We'll be putting out some additional content next week and hope everybody's staying safe and God bless. See ya.